I don't believe there's anything else, Your Honor.
I can't think of anything, Your Honor.
And how about the guidelines?
I believe the guidelines are accurately stored.
We agree.
Thank you. You have a victim here.
I do not believe so, Your Honor.
On behalf of the people, what would you like me to know?
Now, we had in-chambers conversation before we went on the record. And that's because while it is not in the actual language of the sentencing agreement here, the spirit of it was to make it to where he was eligible for boot camp inside the jail. And then when we got PSI, we learned several things. First, the guidelines were higher than expected, and the people learned about his history with the last time he was on probation and the fact that there were more violations than we were aware of, as well as the nature of those. So I want to be clear, if the people had known about those, I'm not sure we would have made the same deal. But that deal was made.
And you're
And
not
that was-
withdrawing it, there's no reason to withdraw, correct?
Correct.
Thank you.
And so the spirit of that deal was for him to be eligible for boot camp. And the other thing we learned from the PSI is that he is technically eligible, but only if he were to discontinue the use of his mental health medications for at least 2 months prior to entry. And while I understand the logic behind it that many of these organizations have, where they want to see where his baseline is at, so they can structure a more specialized plan, it leaves a bad taste in the mouth asking a defendant to discontinue the use of his mental health medication. It's a distasteful feeling, to say the least. And so that is primarily what the in-chambers conversations were about, of how can we still accomplish what we're looking to do here, despite this limitation, without having to make that request. And so I will leave it to the defense and the court to more eloquently explain what the structure is here that we've all talked about and agreed to. But suffice to say, this sentencing will absolutely be violating the Kilgore agreement in this case. And the people understand that and are not looking to withdraw the plea in any way, shape, or form.
Thank you. And before we proceed, sir, just so you remember, you pled no contest to all of these counts. Count 2, police officer assaulting, resisting, obstructing, punishable by 2 years, and docket 2417 FH. Count 4, assault with intent to great bodily harm less than murder or by strangulation, punishable by 10 years. Domestic violence punishable by 93 days, that's count 5. And count 6, domestic violence, 93-day misdemeanor. And those were done under docket 25-1461 FH. And then finally, under docket 25-1465 FH, count 1, punishable by 10 years, witnesses bribing, intimidating, interfering with the criminal case, punishable by 10 years. Now, do you remember those?
Yes,
All right, and you've taken your meds today and everything's good?
yes.
Good. So, counsel, what would you like me to know?
Your Honor, Mr. Jackson has accepted responsibility in this matter and is honestly and sincerely seeking treatment for substance abuse disorder, as well as continuing to treat the anxiety and depression that he has been diagnosed with. He's a hard worker with a lot of potential. He earned his GED in 2022. He was working full-time before his arrest. We're asking the court to consider a sentence that would include credit for time served and 3 years probation to focus on treatment at a facility like Bear River or Cedar Roots with aftercare. We understand that there will be other conditions of probation, batterers, intervention, et cetera. But we believe that would be the best way forward for Mr. Jackson.
Thank you. Sir, what would you like me to know?
I don't know where to start. My 15 months here, I think it's the best thing for me, honestly, the way that my life was set up, the road I was going down. And I gained a lot of knowledge, a lot of resources to better my relationship with my kids, with my family, with the community, period. And I just can't wait to get back to my kids, to be the father they deserve.
And how are you doing on the medication now?
Good.
And you understand that's something you need to stay on, and you need to work with your doctor if there's any changes on that. You can't just go off it, or understand.
Yeah.
All right. Are you good with going into a residential treatment program?
Yes.
Well, it's better than prison, right?
Yeah.
And you know you'll have to comply with all the rules there.
Yeah.
Okay. And you're out of jail time, so if things go really wrong, depending, I mean, I could release you, but if they go really wrong, the only real option may very well be prison. Do you understand that?
Yes.
Okay. All right, as to docket 2417 FH, count 2, police officer assaulting, resisting, obstructing. You will be sentenced to, or you are sentenced to 365 days with credit for 431. You will pay a crime victim assessment of $130 and a state cost in the amount of $68. You will, in docket 251461 FH, count 4, assault with intent to do great bodily harm less than murder or strangulation, pay a crime victim's assessment in the amount of $130 and a $68 state cost. You are sentenced to 365 days with credit for 431 days served. And we'll talk about the remaining time on this file. As to count 4, domestic violence, you will pay a $50 state cost, and you will serve 93 days of credit for 431 days.
Your Honor, count 4 is the assault strangulation, not domestic violence. Do you mean a different count number?
No, I just moved on to domestic violence.
Right, but that's 5 and 6, so I just want to make sure we're.
Oh, did I say 4? Okay,
Yeah.
5 is domestic violence, and 6, same thing, domestic violence. You'll serve 93 days with credit for 431 days. And there's only one, that's one file, so you don't, oh no, you would also pay a $50 state cost on that. So as to state costs, you'll pay the 68 plus the 50 and 50, so that's $168 in state costs plus the 130.
There is one more page, Your Honor.
Yeah, I'm getting there. And then that is the okay, that is the separate file. They just didn't mark it on here. And that is under the 251465 that page. On the third file, witness bribing, you will serve 365 days with credit for 353 days. You will pay a crime victim's assessment in the amount of $130 and a $68 state cost. So the two 10-year felonies, you'll be on probation for 3 years. They will run together. You will, upon acceptance into Bear River or Cedar Roots or similar long-term program, long-term meaning 90 days or more, you will be transported. Either they'll be picking you up or the jail will transport you. They'll arrange that. You must complete the program, including any aftercare, sign all necessary releases, so we verify that you're doing what you need to do. Within 24 hours of your release, you will need to check in with probation and then meet with them as often as they want to meet. Give them your current address, phone number, all that information. If you do not have housing, we need you to let us know so that whatever facility you're in, they can work with probation to make sure you have housing, sir. And do you have stable housing when you leave?
Yes,
All right, very good. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician, and you'll present that within 24 hours. You will not have any guns, ammunition, imitation of a weapon in your presence and your person under your control. You will not associate with any known gang members. You will not wear any gang colors, insignia, or tattoos. You will not associate with anyone in the Michigan Department of Corrections or anyone who's on probation or parole. If you need to do that, as long as they're in good standing, you'll let us know and you'll get my permission. You will allow probation into your residence at any time for probation supervision and submit to a search without a warrant of your cell phone, residence, computer, garage, your premises. Anything that you basically enter, use, or touch, they get to check to make sure you're compliant. Do you understand that?
yes,
And you're able to be employed.
yes,
You will be part of a work seek program unless you are gainfully employed. If you're a full-time student, you will work no less than 18 hours. If you are not a full-time student, you will work a minimum of 30 hours. You'll not give your employer any cause to terminate you. You will follow all aftercare recommendations. You will meet with, you will continue to meet with any therapists. And there'll be a no contact order that's continued with all, or any and all victims here. All recommendations of all treatment providers, including probation, become orders of this court. What else am I missing here? You need to make sure that you're taking an anger management and long-term domestic violence class.
okay,
Okay, and that should be rolled into one with cognitive therapy, and that will be rolled into one. And I don't know if they're going to offer that in addition at Bear River or whatever facility. If they do take it there, shows completion. If not, we'll get you into a program, okay?
And I know that the court had a specific desire to see him be part of a men's group.
Oh, yes, and I do want you to be part of a men's group. A men's group is really, that's for your benefit. It's for people who support each other. And if you are talking with these people and you're telling them some bullshit kind of story, they're gonna call you on it. And you can call them on it. It's really a group of honesty and support. And I think that you need that. You can have family members, you can have a lot of people support you, but it's sometimes those people who've been where you are, who've struggled, who've overcome, that really know when you're not exactly truthful, and you'll know when they're not, and you just support each other to say you can get past this without going backwards. And those men's group we find are really helpful. So probation will help you find the right one for you. Anything else I was gonna order?
I don't believe so. I just want to clarify, to make a clean record, also to clarify for the defendant and the defendant's support systems here, that the release part of this is not him to be released today and then he has to check himself in. It is,
No, he's going
once he
straight.
finds a bed, it'll be from the jail to that facility.
Right. Do you understand that, sir?
yes,
Okay. And you'll not have any assaultive behavior. Do you understand that? Or physical assaultive behavior.
okay,
You'll not commit a crime in this state or any other. Do you understand that?
okay.
All right. Did I miss anything?
Nothing further. Thank you.
Nothing further, Your Honor. Thank you.
You have 42 days to appeal and to request appellate counsel. He needs 3 advice of rights forms.
Oh, yeah.
We missed that. We're not finding this morning. I don't know if more were made.
Wait, break some real quick?
They're not up there on that, on the Elmo.
No,
Are
not,
they-
no,
are they
the
right
price of
there?
rights.
Are
Regular
you
price
that
of
right
rights.
there in front of you?
No, that should
No,
be the
this
appellate
is,
rights, because you don't need to put those up there.
Yeah,
Yeah,
those
that's
are the
legal.
appellate rights, that's what he needs.
Yeah,
We agree.
Yeah, one for each file. We need to do it twice. Do you have any questions, sir?
No.
Okay, I really need your honesty. If something goes wrong, talk to probation. They are not there to punish you, they are there to help you. So you make the most of this opportunity, because if you don't, the prison awaits you. This is about you, sir. So let's make the best of this, that you be rehabilitated once and for all, okay?
Okay.
Any questions?
No, man.
All right, good luck to you, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
thank you, Your Honor.
Two men, two hearings separated by hours in the same courtroom. Two people who, by every reasonable measure, should not be where they are. Lucas Tapio had built businesses. He had skills. He had a life. Then his marriage ended, and he lost the thread. His attorney stood before the court and explained what followed. An organized retail theft operation run by a man who is, at this moment, a fugitive. A man who recruited addicts deliberately, not because he needed partners, but because addicts were controllable. He paid them not in money, but in access to drugs. Lucas was a pawn. He knew it. The court knew it. And he had been sitting in a Michigan prison, 14 months clean, waiting for this hearing to resolve the last of the cases that his addiction had generated across 6 counties. The judge did not let the pawn excuse carry the whole weight. She asked him directly, "What happened?" He said his wife, his kids, the divorce. And she told him something worth hearing. There is no date on a calendar that gives anyone a license to use drugs. There are other paths through loss. The best revenge on a failed marriage is to be extraordinary. His children are watching. They are waiting. Elijah Jackson had a different set of facts: assault, strangulation, bribing a witness. But the same underlying question: what do you do with someone who has real capacity and keeps burning it? The prosecutor admitted on the record that had they known the full picture, the deal might have looked different. They were keeping it anyway. The boot camp option, which everyone wanted, required him to stop his mental health medication for 2 months. The prosecutor called that distasteful. The judge agreed and found another way. The sentence was time served and probation. The conditions were serious. And the last thing the judge said before she released him was that if he found himself in a men's group telling some story that wasn't true, the men in that room would know. That is the job of people who have been where you've been. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.